The orders of your brother, Mr. Justice Mungu, were given at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? Permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the President that will be set for the removal of Deputy Presidents in future and the removal of Presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There is no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, your Lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench to hear these 3 specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number 2, your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 plus 4? What was the necessity of the delegation of this function? Those are pertinent issues, your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's where the constitution is in white and black that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued to summon us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the 5th respondent in Israel. I believe the reason we are here and the reason why we took quorum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the rulings of the court. So in this regard, my proposal is as follows, that each of the parties whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issues, because the 5th respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential of a deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
For the first interested party,
Mr. Lord, just a minute. I was about to interject when when counsel, Mr. not the other one. Yes, Mr. Jagua was addressing, and that is exactly why I wanted us to have order in the way we conduct this proceeding. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which...
The application can only come after I have spoken.
We are now making an application, you respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 546. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Muigai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes.
But you are being invited
to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, Ndegwa and my friend Kibe, is that you are taking the court for a long ride and we're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
Well, Lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My Lords, if it pleases the court, my name is Milimani. I am acting in person. We filed an application for a certificate of urgency on the 8th of October 2024. Before this bench was in panels on the 14th of October 2024. Unfortunately, some of the records we were seeking have been overtaken by events. My Lord, and today, as we have heard, our application has not been placed before you, and we are just concerned that our application will once again overtake our application. My Lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrema about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Boy applying for an adjournment? Because he's saying, and perhaps wrongly, that even the recusal application comes after the termination of the question when paneled. If that be so, and they may leave, they normally leave court, they left Senate, may leave court. We let them say whether they are applying for adjournment.
Is that remark, they normally leave court, whether they left Senate, my palatable in this court, my lord? I need that.
No, because it's an adjournment.
No, is that remark palatable before my lord and my lady? But because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a vain application for adjournment. Because Mr. Wara is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I answered your question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but he did withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem with withdrawing. Okay, my friend, bye. No, I have no problem, my lord. I withdraw the remark, but
Thank you.
there is practice.
Thank you. Let me now address the question as addressed. My lord, Professor Agenda was my teacher and my mentor for many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through Lanet's colleagues, KIMEUMANA, and Lanet colleague, Mr. Gachagua, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Kidumwega, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. They actually knew of it, and or should have, they would have found out. The letter which was written this morning, which it was received on the 20th of October, has actually one pertinent question disposed, whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what you are told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues, the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed
justice in accordance with the framework in Article 48 of the Constitution. But, my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of that kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the applications which have been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But, my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So, my Lord, what is the fuss about it? So, my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And, my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And, my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.